Absolutely. I can take the role of a judge in a mock hearing or simulation. To do it properly, I'll need a few things first. 1. Brief facts of the case: what happened at the traffic stop, when, where, and why the ticket was issued. 2. Plaintiff's argument: what they claim happened and why they believe the ticket or harassment is unjust. 3. Defendant's argument: the officer or issuing party's justification for the ticket and their defense. Once I have that, we can run a structured hearing where each side presents their case. I can ask questions and then issue a judgment or ruling based on the arguments. Do you want to start by giving me the facts and arguments for both sides? Got it. Let's frame this as a formal hearing simulation. I'll act as judge. Here's how we can proceed. You can present Plaintiff Thayer and De Frederickson arguments, and I'll allow each side to make their points, ask clarifying questions, and then render a ruling. I'll also note the legal context, especially regarding harassment and TRO procedures. Let's start with the plaintiff side. You can present their argument, including why they believe Frederickson's actions constituted harassment. Once that's done, we'll hear the defendant side. Go ahead and present the plaintiff's argument. Understood. I'll summarize the plaintiff's argument clearly from what you just provided, as I would as a judge taking notes. Plaintiff's argument: Thayer. 1. Frederickson is a convicted sex offender with a documented history of making threatening videos toward the plaintiff and other parties. 2. On the date in question, Frederickson followed Thayer's vehicle aggressively and drove in a manner intended to intimidate after Thayer exited the courthouse. 3. Frederickson has a history of attempting to use TRO's PPOs against Thayer and other defendants as a legal weapon. Prior attempts were dismissed. 4. Frederickson has made explicit threats of violence, including statements about firearms and targeting the plaintiff and others, causing Thayer to reasonably fear for his safety. 5. Due to this fear, Thayer chose not to attend court to avoid potential confrontation with Frederickson. 6. Frederickson's conduct on the date in question, following Thayer after leaving court and shouting at him, constitutes harassment under these circumstances, creating fear for personal safety. Now we can move to the defendant's argument. Present their side, including their defense regarding the harassment ticket and the claim about serving the TRO. Understood. Here's the defendant's argument Frederickson summarized formally as I would record it as a judge. Defendant's argument: Frederickson. 1. Frederickson had just obtained a temporary restraining order against Thayer in court and intended to serve it immediately. 2. Upon seeing Thayer leave the courthouse, Frederickson followed his vehicle to effectuate service of the TRO. 3. Thayer allegedly avoided service by driving away. 4. Police intervened, observed Frederickson following Thayer, and issued a harassment citation under Colorado Revised Statutes 818-9-11C. 5. Frederickson claims the citation was improper because he was attempting to serve the TRO, not harass Thayer. 6. Police reportedly reviewed the TRO and instructed Frederickson to return it to court, refusing to serve it on his behalf. 7. Frederickson also notes procedural concerns with the citation and claims he informed the police, referencing civil claims already filed against other parties. As a judge, I now need to analyze both sides against the law. Key points here: harassment, CRS Spec 18-9-111C, engaging in conduct intended to harass, annoy, or alarm another person, including following them repeatedly, can constitute harassment. TRO service. A party to a case generally cannot serve a TRO on the opposing party themselves. Service must be done by a neutral third party, sheriff, or process server, unless the court explicitly authorizes otherwise. Attempting personal service as a party could itself constitute harassment if it creates fear. Intent and effect. Even if Fredrickson claims he was serving a TRO, the manner of following the vehicle, shouting, and sprinting after it could reasonably be seen as harassing and alarming. From these facts, the central legal question is, did Fredrickson's actions constitute harassment under the statute, despite his claim of serving a TRO? If you want, I can now issue a mock ruling as the judge, laying out reasoning and outcome based on Colorado law and the facts presented. Do you want me to do that next? Here's how I would rule as the judge based on the facts and arguments presented. Case: harassment citation issued to Rex Allen Fredrickson, jurisdiction Colorado. Statute: CRS, PAF 189111C. Ruling: after reviewing the evidence and hearing arguments from both parties, the court finds the following. 1. Facts: Thayer was waiting outside the courthouse when Fredrickson exited after obtaining a TRO. Fredrickson followed Thayer's vehicle, shouted at him, and attempted to approach him physically in a manner that caused alarm. Thayer reasonably feared for his personal safety given Fredrickson's prior threats, history of harassment, and the nature of the pursuit. Fredrickson claims he was attempting to serve a TRO. However, as a party to the case, he is not legally authorized to personally serve it on Thayer. Police confirmed this and instructed him to return the TRO to court. Legal analysis. Under Colorado law, harassment includes conduct intended to alarm, annoy, or intimidate another person. Repeated following, aggressive behavior, and verbal taunts can satisfy this definition. Fredrickson's stated intent to serve a TRO does not excuse actions that caused alarm or created fear. The method of attempting service, chasing and shouting at a moving vehicle, was objectively threatening. The law requires service of restraining orders to be done properly and safely. Personal pursuit in a manner likely to alarm the other party is not legally justified. Conclusion: the court finds that Fredrickson's actions constituted harassment under CRS CACA 18-9-111C. The citation issued by the police is upheld. The fact that Fredrickson had obtained a TRO does not excuse or legalize following and shouting at Thayer's vehicle. Order: the harassment citation remains valid. Fredrickson is reminded that attempting to serve a restraining order personally against a party to the case is not legally permitted and may result in further criminal liability if repeated. Any concerns regarding TRO service must be addressed through the court or law enforcement as instructed. If you want, I can also draft a shorter, court-ready version of this ruling in formal judicial language that could read like an actual decision. This can be useful if you want to include it in documentation. Do you want me to do that?